A writ of garnishment was served on my bank account, but my bank account is exempt. Hi, I'm Jonathan Alper, Asset Protection Planning Attorney in Orlando, Florida. That kind of statement I often get when people contact me because their bank accounts have been subject to writs of garnishment. They say they've read the website that I have published, and they learned from my website that all the accounts they have at the bank are exempt. Perhaps they're joint accounts with their non-debtor spouse, or perhaps the accounts include wages that they earned as a head of household. So they're amazed and angry when a bank has frozen this accounts with a writ of garnishment. Well, here's what you need to understand. When a creditor files and serves a writ of garnishment, they are not garnishing your accounts or anyone's individual accounts. They're garnishing the bank where they think you may have property. And the writ of garnishment properly serves to freeze any account at the bank that was served that has your name on it, whether or not it's exempt. It also, and people sometimes forget this, it will freeze a safe deposit box because you may have valuable collectibles or money inside the safe deposit box. Well, what do you do if you are served with a writ of garnishment and you think your accounts are exempt? Well, the first thing is do not get mad at the bank. Calling the bank clerk and forcibly saying that the bank has made a mistake because they froze your exempt account, that will not get you anywhere. The bank is required by law, and for their own protection, they will freeze any account with your name on it, and you're responsible for getting the garnishment released. One thing you can do, which is easy, is you could fill out the claim of exemption form that you will receive when the creditor serves you notice that your accounts have been garnished. You'll send the exemption form to the creditor and also to the court, and you are supposed to get an expedited hearing on your exemption. If you have substantial sums of money involved, I recommend that you contact an attorney and have the attorney not just wait for the exemption form. The attorney should immediately file with the court a motion to dissolve the garnishment because the money is exempt. Keep in mind that you also have a potential right to sue the creditor for a wrongful garnishment if they have garnished exempt money, especially if they have reason to believe that the money is actually exempt in the bank. Garnishment is complicated. The statutes and procedures are very detailed, and creditors frequently make technical mistakes when they do a writ of garnishment. Again, an attorney who works in the garnishment area will be able to find these defects and use them to dissolve a garnishment, even if the bank garnished money that's not exempt. If you find yourself a victim of a garnishment writ and believe that your money should be protected, give me a call. I'm happy to help. My name is Jonathan Alper, and my number is 407-444-0404. And thanks for watching the video.